morning. The 36th District Court in the state of Michigan is now in session with the Honorable Judge Donald Coleman presiding. While court is in session, there will be no eating, sleeping, talking, or gun chewing, or reading any materials. Thank you.
All right, this is case number 24-16935. This is Capital One versus Tyrone C. Dale. The matter is before the court set on for hearing on a motion for summary disposition. It's also set on as a pretrial conference hearing. Your appearance for Capital One, please.
Good morning, Judge Coleman, Cezanne Barta, P65425.
All right, good morning to you, Mr. Barta. I'm looking now for Tyrone Bale. Mr. Bale, if you're on this Zoom, please say something at this time, sir. Tyrone Bale. Looking for Mr. Tyrone Bale. If you're on this Zoom, please say something at this time. If you are on mute and having difficulty, then if you hit *6 on your device, that will allow you to speak. Mr. Tyrone Bale, if you're here.
He was there.
My clerk informs me that he was here. Counsel, did you have a chance to?
Hello. This is Tyrone
yes.
Bale.
All right, thank you, Mr. Bale, and good morning to you, sir.
Good morning.
All right, Counsel, I do see that it's set for a hearing on a motion for summary disposition. Have there been any other discussions or any updates regarding this matter, Mr. Barta?
There have been no discussions, Your Honor, and no updates.
Okay. All right, and I don't see where there is a response to the motion, although I have a filing date of that motion as the 31st of March. And so that puts us about 15 days out from the actual filing of the motion. Mr. Bale, I know that you haven't responded to the motion, although the time is not actually run on that. So you did receive a copy of the motion for summary disposition, is that correct, sir?
No, I haven't, but I'll have to check the mail to make sure.
Yeah, I'm sure you have, but you haven't checked the mail. That's crazy. But anyway, so what are you? This case is they're suing you obviously for this $14,000 that's involved here. Are you trying to get this worked out or what? Because it seems like this comes as a result of some credit that you used previously, and in regards to Capital One, and you didn't pay under the contract. So talk to me, sir.
So you said that this. I couldn't hear you clearly. It was kind of muffled.
Yeah, it seems like at least from the documents that I've been able to review, it does seem like this is a debt that you incurred, but I'm not absolutely sure of that. So are you challenging the debt, or are you trying to find a way to work out a payment arrangement?
Oh, I was challenging the debt.
All right, very well. Thank you. Mr. Barta, I don't know that enough days have expired for me to address the motion at this point, because it looks like it was filed like 15 or 16 days ago. And so I would want to, well, actually under the order that I sent, I indicated that as long as there was 10 days before the hearing, so that would give you the time allowed between filing the hearing under paragraph 6 of the scheduling order. So I'm going to allow you to go forward on your motion at this time based upon the court's order in the scheduling order under paragraph number 6 in the court's order. You may proceed at this time, sir.
Thank you, Your Honor. The motion is based on MCR 2.116 C9 C10. There's no genuine issue of material fact to move forward to trial. This is a very straightforward collection matter for credit extended, payments made, and a default provision. Capital One Bank is a direct client, so there's no chain of title bill of sale information needed. Mr. Bell used a credit card, made payments on that credit card, and defaulted on that credit card. Billing statements attached to our motion show that statements were mailed to his address and he made payments thereon, which comports with the account stated theory. Mr. Bell did not file a response to our motion, did not file a counter affidavit. And to be honest, it's a little shocking that he's disputing this debt at all, and that he's not trying to resolve. But plaintiff is requesting that the motion for summary be granted at this time.
All right, Council, before I go to the other side, I'm seeing where, of course, you attached to your motion a number of billing statements. And as I look back through some of them, it seems like the highest amount that I saw on one of the billing statements was in the nature of about $7,000. Of course, the claim here is for $14,000. Can you bridge that gap for me, if you will?
So I'm gonna have to go through those with you.
I'm sorry, sir.
I'm gonna have to go through those billing statements to be able to answer your question.
All right. And I guess I was looking for a maybe what I'm looking at is I'm looking at the most recent billing statement that was attached to your documents.
Your Honor, there's a billing statement dated July 6th, 2023, whereby the balance is $6,800, and then there's $5,457 worth of transactions, which bumps that up to $12,000. And I believe that would answer, I think that answers your question.
Yeah, okay, I do see that billing statement as a part of your motion, and it indicates a new balance as of as of July 2023, a new balance of $12,187. Just one moment, Council. And I also see that amount ascending in some subsequent statements. I'm looking at the statement from November of 2023, that amount is at $12,890. And then I'm looking at a statement from December 2023, that amount is at $13,192. All right. I see the order that you put the statements in. That's why thank you, Council. All right, Mr. Bell, tell me why the court shouldn't grant the motion for summary disposition. This looks like a bill that you had, you made payments on it, and then you stopped making payments. Talk to me and tell me what's going on.
And that's the challenge of the debt is actually what you were asking about. The credit limit was $7,000, and one of their associates or whatever let a transaction of $5,000 go through, which shot it up to $12,000, which went over the credit limit. And he's saying that the attorney said that they were charges that were racked up, but those weren't charges that were racked up. The actual charge was from a rent-a-car company, which was only $1,000, and the rent-a-car company overcharged the transaction and overcharged the transaction. It was declined the first time. I called in. I said, well, they shouldn't, that's not an accurate charge. They shouldn't be paid. If that happens again, it should be declined again. The next time I got a bill from Capital One, they had moved forward and let the transaction go through for the second time. So I talked to someone else from Capital One and asked them, why did they let the transaction go through? Because it was such a large transaction. They have flagged any transaction for $150 to $300 when I've made the transaction. So I'm trying to figure out why they let a $5,000 transaction go through. That's more than half the credit limit,
All
and
right,
they're
thank
asking me to pay. Yeah.
thank you, Mr. Bell. Mr. Barter, the transaction that, or transactions that went over the credit limit, and how that might impact, issues here, sir.
Your Honor, I can't really address the particular transaction, other than the fact that the rental car company ran that transaction through. Whether it's correct or incorrect, I can't really comment on it, but the bottom line is that it was run through and that credit was extended to the defendant. If the defendant has an issue with the rental car company, then he may have recourse against that company. But the fact that that charge went through and Mr. Bell made payments on it comports with the account stated theory in the state of Michigan. So I don't really know how I can address a third party that mischarged something to a credit card that was obviously given to them for, for renting a car.
Yeah, it would sound like that's an issue between, Mr. Bale and the place where he rented the car from. I guess the issue that he was raising, if you have any comment on that, was that, he only had a credit limit of X amount, and the charge was allowed even though it was over his credit limit amount. I think that's the issue he's addressing.
And that I didn't make payments on that.
All right.
I didn't make payments after that charge was made. There was the dispute was that's when the dispute started between me and Capital One, and then I told them that until they clear that up, I won't make payments. They actually took the charge off. They reviewed the charge, and after they reviewed the charge, they put it back and tried to. Well, they took the charge off and said make a payment. We took the charge off. We're gonna solve it, and then I think a payment was made because they took that charge off, and then after they put the charge back on, I didn't make any payments further and said that charge shouldn't be on there because it went over the credit limit.
All right, thank you very much, Mr. Bale. Anything finally, Mr. Barter?
No, Your Honor. I mean, I've had many disputed charges with my credit card company. They always take the charge off of the bill until they come to a conclusion, and then they make a determination whether to put that thing back on. So if I had a trip or an Airbnb or a rent a car and I called my credit card and I disputed saying, hey, that $3,000 should not have been on there because because the third party made a mistake or I wasn't happy with it or whatever reason, they will always put the $3,000 back on my account until the pendency of their transaction. And if they put the money back on as saying, no, you made the charge, well, then my recourse is not with the credit card company. My recourse is with the third party that charged the card, unfortunately.
All right, thank you. I've heard the arguments on the motion for summary disposition. I've heard the opposition to the same, although there's not a written response in these parties. We're going to get to the critical issue here. It seems that the defendant raises issues that a charge should not have been allowed on his credit because he had a limited amount of credit available, and that when he requested it be removed, it was removed and then placed back on after an investigation. But the fact of the matter is that the arguments here and the statements by the respective parties establish that there is a contractual relationship that exists between the parties, and that contractual relationship led to the use of credit and led to charges being made on the credit that was made available. In fact, the charges were allowed that were in excess of the amount of the credit limit. Not unusual for persons to make charges over their credit limit. The issue here seems to be that Mr. Bale has objection to the underlying creditor who in fact made the charge to the credit card, and that he disputes with the car company, I believe as he indicated, that it should not have been that amount. He certainly has a right of action against a third party that made a charge on his car. But he obviously provided information to them that allowed them to make that charge, and that makes him, causes him to become responsible for the same. As I've looked at this very carefully, I do not see where there's a genuine issue of material fact. In fact, I don't see where there's a factual defense to this matter that has been pled. Accordingly, the motion for summary disposition is proper, and it is supported by the facts and circumstances of this case. There is no genuine issue of dispute in this matter. For that reason, the motion will be granted and judgment will be allowed on the granting of the motion in this matter. That is my order, and I don't think I saw an order attached to the motion, counsel. So you'll need to submit an order. And I'm looking again just to see if I might miss it. It's there.
No, I think you're right, Your Honor. I will submit one this afternoon.
All right, thank you. Good day to both sides. All right, this is case number 24-175-86. This is Citibank versus Kyle J. Tate. Court set on for a status conference. This is the first hearing regarding this matter. Your appearance for Citibank, please.
Good morning, Your Honor. Good morning, Your Honor. Keith Sparks on behalf of Citibank, P77485.
Thank you, Mr. Sparks, and good morning to you, sir. I'm looking now for Tate. Mr. Tate, if you're on the Zoom, please say something at this time.
Good morning, Your Honor. I'm present.
All right, thank you, Mr. Tate. Good morning to you as well. I see that the claim that is being brought in this matter, I believe I saw in the nature of about $3,000, although I didn't think this directly. Have the parties talked about this at all?
We have, Your Honor, and the parties have reached an agreement. We're going to send Mr. Tate a consent judgment. It's going to be for the full amount. However, there's going to be language in there that the parties agree to the settlement amount of $2,136 to be paid at $59.50 a month, beginning on May 16th.
Give me the monthly payment amount again.
$59.50.
And you have a commencement date on that payment?
May 16th, 30 days out.
All right, Mr. Tate, you've heard the rough terms as set forth regarding this matter with an agreement to pay it off at an amount $2,136 in increments of $59.56 a month, commencing on May 16th. Is that your agreement regarding this matter, sir?
Yes, sir.
All right, well, I will note to the file as I have the information that's been submitted, and I will await the submission of the order of this matter, and we'll deem that the case has been resolved. All right. Good luck to both of you today.
Thank you, Your Honor. Thank you, Mr. Tate.
Have a good one. Thank you.
The court now calls case number 25-143763. This is Credit Acceptance Corporation versus Aaron Rippey. The matter is before the court. It is set on for the first hearing regarding a complaint alleging damages of $21,450.93. Today is the first hearing regarding this matter. Your appearance for the plaintiff.
Good morning, Your Honor. Alexander Popov appearing on behalf of plaintiff PA 4370.
Mr. Popov, good morning to you, sir. I'm looking for Mr. Aaron Rippey. If you are on the Zoom at this time, sir, please say something at this time. Mr. Aaron Rippey. The court did receive an answer form that was filled out and submitted to the court on February the 13th. The form is, there's some general disagreements and some statements of agreement. No particular facts have been set forth, but I did set it up for hearing to give a defendant an opportunity to comment and to submit any information to the court. The court did send the notice out on February the 18th, setting today's date as a hearing. Counsel, you've had any contact with Mr. Rippey?
No, Judge, we have not.
I see some. Just give me 1 second. So, counsel, your pleasure regarding this matter, it appears the defendant has not appeared.
Judge, we would move for a default judgment today.
All right, the court will find that defendant is in default on the failure to appear as directed to do so, and the court will allow judgment upon that default that is now entered. So ordered.
Thank you, Judge.
Thank you, Councilman Davis. The court calls case number 0613-2204. This is asset acceptance versus Lamal McClendon. The matter is before the court on the following of objections to a writ of garnishment. This writ of garnishment is in relationship to the Michigan Department of Treasury. The record should reflect that a judgment was entered in this matter, on the 3rd of November 2006, and that judgment was subsequently renewed, and a balance remains, and therefore the garnishment has been directed to the Department of Treasury. All right, your appearance for asset acceptance, please.
Good morning, Your Honor. Michael W. Sefton, P. 31320, appearing on behalf of Asset Acceptance.
All right, thank you, counsel, and good morning to you. I'm looking for Lamal McClendon. If you are on the Zoom, please say something at this time.
Good morning, Your Honor. I'm here.
All right, thank you, Mr. McClendon. I do see you there, sir. I looked at your objection straightforward. You said the judgment has been paid. It seems that there is some disagreement in that regard. Did you ever receive a satisfaction of judgment or anything?
All I received is I know since 2006, since I got the complaint, they took the whole amount that they said that I owe, but every time I do taxes, they come up with a whole different amount and they keep on taking it.
Now, I'm sure that interest has accrued on some of this, but you really started out with a judgment that was only $1,370. Counsel, tell me what's going on, sir.
I'm pleased to court, Your Honor. I did not receive a payment record from, let's see, the original was, let's see, the last paid. I think the only way we've ever been paid on this is by garnishment. I don't know if he's ever tried to set up a payment plan or anything else, so. And he didn't attach any of the proof so that I can take a look at it to see what he's saying is taken, when or how. It's hard to analyze his answer when it says this has been paid, but you don't provide any information for the court or for the opposite party to be able to tell what he's saying and why he's saying it.
Yeah, well, it's the duty of the of asset acceptance to provide some type of accounting as to what has occurred. And I guess you've indicated today that you don't have any kind of printout showing.
I have the judgment amount, the interest amount, and the current balance, but no record of payments by him. He's saying that money's been taken, but it's his obligation in this particular matter to provide the proof of the judgment that it's been paid.
Well, you articulated that differently the first time around. So let me be real specific on what my question is.
All right.
Is whether or not you have the complete records of asset acceptance in regard to this particular account.
I have the current balance of the account and the collection accounts, but
cut you off there, but I want to move on. That does not answer my question as to whether or not that provides you with a complete readout. Because this gentleman is saying you pay something, and obviously one of the first places to find that out is with the asset acceptance records that will show a history of anything that is paid. Are you saying that the record history shows that there are no payments, or you're not sure if there were payments talking?
Hang on just a moment, Your Honor. I apologize here.
Not a problem.
Well, I have all the paperwork, Your Honor. I have the documents when I told
Mr. McClendon, I'm coming back to you in just a moment, sir.
Okay.
Let's see. I have no record of payments, Your Honor. I just have the continuing interest and the renewal of the judgment. It started all the way back at $559, and it's now grown to a current amount of $2,287.43.
All right, very well. So, Mr. And I called you McClinton. I know your name is McClendon, so my apologies, Mr. McClendon. You said that you have some documentation of payments over the years since the judgment was entered in 2006. What do you have by way of payment, sir?
I actually went down and got the documents from the court building. They gave me every documents on here since I got paid, because I got paid every time out of garnishment, so they take it out of my taxes. And
Okay, you told me. Let me stop you. You told me that already. Okay. You know what I'm asking about. How much money are you able to show has been paid on this judgment? Did you come up with a total, or what do you have, sir?
Let me see. I'll have to come up with a total.
All right. So, but you're sure that money has been taken from you that's been applied to this account, not just if you have some other judgments out there, garnishment could be applied to those other judgments. Are you sure that it's in relationship to asset acceptance?
To access to it's all connected. It's in 2006.
So what I'm gonna do here is I'm going to adjourn the hearing until the 29th of April, and you need to get whatever information you have. You need to get a copy of that information to Mr. Sheldon, asset acceptance, and you need to get a copy to the court so that I can make a determination on this matter, because they're showing that you made no payments. You're saying that you made enough payments and early enough that this should be paid off. That's a significant goal. I would do it next week, but I'm going to be away next week, so that's why I'm setting it on the.
May it please the court?
Mr. Sheldon, just one moment, sir.
Can you do it on the second? You got like 15 cases in 2 trials. On the 29th.
Can I do it on the 30th then?
Yeah, you can.
Yeah, the 30th would be the date. Mr. Sheldon, sir, go ahead, sir.
Mr. Septon.
Mr.
May it please the court, if I can be in a breakout room with him, maybe he can give me an email address. But knowing how slow some of this stuff works, I've asked the court to adjourn it for 30 days and put it out there so he has adequate time and everybody has adequate time so we can come back and be prepared, Your Honor.
All right, so yeah, that makes a whole lot of sense. So let me go ahead. Let me go ahead and set it for the 21st of May.
May 21 at 10 o'clock, Your Honor.
And, yeah, 10 o'clock is fine. May 21st.
By Zoom, Your Honor.
Yes, by Zoom. All right. And I'm going to put
if you can put me in a breakout room with him, maybe we can get the information transferred more quickly.
That makes sense. All right. So I'm sending you a notification now, sir. And Mr. McClendon, I'm sending you one as well. And both gentlemen, my apologies on pronouncing your last names. I don't know why.
That's all right. A lot of people have met me over the last 45 years and none of them want to remember my name correctly. Thank you, Your Honor. We'll go in the breakout room. We will not come back to the court, though. Thank you.
You got your date of the 21st of May at 10 o'clock.
Thank you, Your Honor.
That's that. The court now calls case number 15-119971. This is Midland Funding LLC versus Cesare Blacksmith. Hopefully I've got that first name correctly. The matter is before the court.
Right, Your Honor.
Objections to a writ of garnishment. Your appearance for Midland, please.
Good morning, Your Honor. Jeffrey Beers, P 41693 on behalf of Plaintiff Midland.
Thank you, Mr. Beers, and good morning to you. I'm looking for Mr. Blacksmith. If you're here, say something at this.
I'm here.
All right.
I'm
thank
here,
you, Mr.
Your Honor.
All right, thank you, sir. Good morning to you. I looked at your objection. You said I never come business, or I never
I've
had, never done business with this company. It's the wrong person or someone has used my name. All right, so that's the nature of your objection that you raised in this matter. Is that correct, sir?
Correct.
Well, you know, the law does not allow you to object to the in a post-judgment proceeding with an objection that you have to raise in a pre-judgment proceeding. In other words, it sounds like you are alleging that the judgment should be set aside. You'd have to file an appropriate motion to address that. You can't address that in a post-judgment hearing. There's a specific courtroom that does not allow me to consider that. Let me hear from Mr. Barris, and then maybe the two of you can talk, and we'll figure out where to go with this, sir.
Your Honor, if you'd like, we can go into breakout room. It might save some time.
Yeah, let's do that, and then you'll come back in the courtroom and let me see where things are at that time. Maybe you can find a way forward regarding this matter. So I'm sending you a notification for a breakout room, and I'll be holding the file and waiting to talk with the two of you on the other side at that time. So there's your notification.
Okay, I haven't got any. Oh, here it is.
Got it, Mr. Blacksmith? All right, the court now calls 24-16-1273. This is Universal Collections LLC versus Asia Greer and Asia Greer. Now, the matter is before the court on the filing of objections to a writ of garnishment. This is regarding Asia Greer. The matter is, I also see an objection regarding Asia Greer. And your appearance for Universal Collections, please. Universal Collections. All right, do I have Asia Greer? I have Aisha Greer.
Judge, we don't see that on the docket.
I said it's okay.
What is that, Judge?
I'm sorry.
What is that case number there?
This is Kenneth Johnson. Yeah, this is not my file.
Okay. Yeah, that's there.
And set for today, so somebody needs to get it to you.
Yeah.
All right. This is case number 16-11-1138. This is Universal Collections versus Anthony McClendon. The matter is before the court on objections to a writ of garnishment. All right, your appearance for Universal Collections. All right, do I have Anthony McClendon? Now, is this the same file that I had previously for the McClendon matter?
Yes, which one?
And Universal Collections versus McClendon?
No, McClendon, that's Lamar McClendon. And this one is Anthony McClendon.
Okay.
Different.
Do I have Anthony McClendon on the Zoom? I have Universal Collections on the Zoom. It looks like neither party has appeared regarding this matter. I do have someone in the. Let's see what this
Good morning, Your Honor.
Good morning. Who are you?
I am Anthony McClendon.
All right, I'm on your case now. Universal Collections versus Anthony McClendon. The matter is before the court on objections to a writ garnishment regarding. All right, thank you, Mr. McClendon. I don't see the plaintiff on here, but I see that there is a judgment. Mr. Barris, are you on any other matter with me this morning other than the case that you have there?
Nope, just the one.
Okay, all right. So, Mr. McClendon, I received your objection. You said the writ was not properly issued because you have no knowledge. What are you talking about, sir?
Well, I have the knowledge, but I don't owe him $3,000. We moved. I got into a domestic investigation and went to jail for one night, lost my job, and me and Sonia were done. We moved out of the house. We moved everything out of the house. Everything was correct. Nothing was damaged. No anything. Everything was moved out according to plan. Then I went to turn his key in, and I remember him calling me the N-word, which infuriated me. This was from years and years ago. I let it pass. I didn't think about anything, or I didn't know that he was suing me in the first place. So I'm just trying to get this matter resolved because I'm trying to get my life is all the way in order, and I'm just trying to get this matter resolved today because I don't see how I owe him $3,000 and everything was paid and we left the house in timely manner.
All right. So the problem is that back in 2016, a judgment was entered against you. That judgment was for $3,771.55. That judgment remains in place at this time, and that provides the basis for the plaintiff, Universal Collections, to pursue you. And that's what's going on here. That judgment has been around for almost 10 years now.
Right. I had no knowledge of it until I just hit the lottery and they took the money. And I was like, huh, for what? So I'm here now to try to close this matter and move on with my life, Your Honor.
Yeah, well, you can't do it. You can't do anything as it relates to the garnishment at this point. If you believe that the judgment should not have been entered, or you want to object to that, you have to file a motion to try to get that judgment set aside. As long as that judgment is in place, the plaintiff has the right to use that judgment to collect. And so what you're doing is you're raising pre-judgment issues that should have been raised before that judgment was entered about 10 years ago.
Right.
You're trying to raise them in a post-judgment hearing, and you can't do it that way.
Okay.
So I don't see a valid objection to the writ of garnishment. You still, even 10 years later, you still can file a motion, for example, to try to get that judgment set aside. You also can reach out to the Universal Collections to try and get this resolved, because, like I said, time is not on your side because that judgment has been in place for approximately 10 years. So today, the only thing that I could determine today is that you don't have a valid objection, because the only valid objection that you could possibly raise, like under these circumstances, would be that the funds are exempt, or that you file bankruptcy, or you have a payment plan or something along those lines. So none of that exists. So I would have to conclude that the objections at this time are invalid. Any funds withheld will be released to the plaintiff and applied towards paying on this judgment. The other problem or concern here is that with it being that long a period of time, that interest has accrued on that judgment as well. I don't know what that would be, but that's a possibility as well. So I do wish you well. And how much money did you win, or how much did they take from you as a part of your win?
$3,200. They took $3,200 from me.
Yeah, well, and I take it that your winnings were more than 3,200, true?
No, just 3,200.
Oh, so that what I was getting at is that obviously, if you won 10,000, they only took 32. That would be a way of telling us that.
No, they took it all, Your Honor. They took it all.
Yeah, you're not listening, so I can't tell you the other part that I'm trying to get at. You keep interjecting. So I don't
even play the lottery though, so it was just a lucky draw. That's all.
I wish this bet had been, but they had a little money for the song, but they got you. So I wish you well. Nothing I can do about that now, but again, you do have some avenues that you want to explore that you can explore. So, all right, all the best to you, sir.
Okay, so what can you tell me what avenues I can go to try to resolve this again?
Well, I gave you a little tip off, but as a judge, I can't give you legal advice. All I'm saying is that you're attempting to attack the judgment itself. If you believe that that judgment should not have been entered, then obviously the way that you go about doing that is to try and you get that judgment set aside. And of course, they may further information, but I can't give you advice because I'm a judge and it would not be right.
Okay. All right. I appreciate it. So they just so the $3,200 they saying I owe $5,000, but I don't even understand how or what. So they just took the $3,200 and do I still owe a balance after they done took the $3,200? Do I get a receipt?
So that's why I was asking you those other questions about how much money you won, because if they took that, if they took all of it, that probably means that there's a balance still. And that balance is probably as a result of the judgment that was in. So as a result of interest on the judgment over the past 10 years. So you need to reach out to the agency to try and get a balance from them. Find out how much they claim that you owe them. And then maybe even try to work out a way to get that portion resolved for something less than the full amount. But you have to work on those things. I can't guide you through that because the law doesn't allow me to do that. All right. Good day to you, sir. I'm on to another case. We're back on the record.
Appreciate it. Thank you.
Back on the record regarding 9971, and welcome back, Mr. Harris, and welcome back, Mr. Blacksmith. I know you got disconnected, but fortunately you came back in. Mr.
Your Honor, we had an opportunity to speak in breakout room. We were not able to resolve, so let Mr. Blacksmith proceed with his motion.
All right, and Mr. Blacksmith, you indicated that you never had any business with this company, and that does not provide a valid objection. You would have to use that to somehow go and try and get that judgment set aside in this matter. The judgment was entered on the 25th of November 2015 for $757.61. So that judgment has been around since 2015. And it looks like, just for a moment here, just a little bit of history here. But yeah, that's as much as long as the judgment is in place, the plaintiff has the right to pursue collection on it. If you believe that it should not be you, then you have to take some steps to get that set aside.
I understand that, Your Honor. Your Honor, is it possible? Hello?
Listen to you.
I was wondering, is it possible that it should be postponed well, can this be postponed until I can file the appropriate paperwork?
No, it doesn't work. It doesn't work that way. Let me ask you, this garnishment regarding your wages?
Correct.
All right. So has any money been taken from you yet?
Some years ago, maybe like 2 years ago.
Let's stay with me now, okay? I gotta move on. Any money taken under this garnishment?
No.
Okay. So you get paid weekly, monthly, every other week?
Bi-weekly.
All right. And how much do you usually bring home?
It depends on my hours. I'm in nursing, so sometimes I work a lot of hours, sometimes I work none. So somewhere anywhere between $200 and $2,000.
Okay, so what I'm trying to get at is what your garnish rate might be. It's going to be 25%. So I kind of need you to tell me what it kind of looks like on the regular, because otherwise I got to leave the garnishment in place at the full amount, which means they'll take 25%, versus a scenario where I could set that garnishment at a fixed rate to try to get this paid off instead of the full amount. So for example, if you bring home $2,000, that means that $500 of that will be subject to garnishment.
Correct.
Yeah, so, all right, so what do you?
That's an awful lot of money.
Yeah, but you're not following me. Okay, how much you want to pay on this while you think about how you want to attack?
Okay, so can I pay $50 a month until I can do whatever it is I need to do?
You say 50 a month. I need you to answer that question for me. You think I'm gonna let you pay $50 a month? No.
No.
Not when you got a garnishment that's gonna pay somewhere between $300 and $500 a week. You gotta come a little bit better than that. Counsel, what do you have as a balance on this judgment?
Yeah, the current balance is $772.61. We've never received any payment on this judgment ever in the last 10 years. I'm looking at the disclosure of his garnishment. He makes $2,759 every 2 weeks. The garnishment amount that is coming is $625.17 for this pay period. So it will be paid off, and one more garnishment and any overage over $772, we will refund back to him. So the garnishment that's coming is just about going to pay it off.
So you've already got notification that some money has been withheld, correct, counsel?
No,
Yes.
no.
Yes, we haven't received the check yet, but yes, I'm looking at the disclosure, and yes, $625.17 is being withheld.
All right, so I'll release the amount that's been withheld to go towards the judgment, towards satisfying the judgment. And counsel, what would be the balance after that?
Balance after that would be, on my calculator. The remaining balance would be $147.44.
All right, so what I'm going to do is I find the objections are invalid. Any funds withheld will be released to the plaintiff. Now, you only owe about $150 after they take this garnishment. Garnishment. So what I'm going to do is then I'll leave the garnishment in place, and I'll make sure I'll indicate the garnishment should be up to $200. So they can only take 200 more, and then any balance will be refunded to you, Mr. Blacksmith. All right.
I mean, yeah, I feel like I'm being robbed, Your Honor, but I mean, what can I do?
Okay, well, the other thing is to just leave the garnishment in place at full throttle, and they keep taking your money and then refund it to you later. What I'm saying to you.
No, I agree with what you're saying. I appreciate what you're doing, but I'm making a statement that I still feel like I'm robbed for something I didn't, monies I don't owe.
I gave you some information as to what you have a right to do if you wish to do it. You understand what I'm saying? If you want to attack that judgment, the law still allows you to file motions and whatever you want to file to try to address that. But right now you have a problem because there is a judgment in place. That's the problem. That judgment allows all kinds of collection stuff to take place. So you still, they're two separate issues, okay? This is going to resolve the garnishment issue. If you want to attack the judgment, you still have the right under law to bring challenges to that if you choose to do so.
Oh, I will.
All right. I wish you well. You'll receive my order in the mail in the next couple of days, and I wish both sides well. Good day to you.
Okay, thank you. No.
This is case number 12-103297, National Collegiate Student Loan versus Mohammed Barakat. The matter is before the court on the following objections to a writ of garnishment. The record should reflect that a judgment was entered in this matter on May the 11th of 2012 for $11,000 $21.15. It looks like that judgment was renewed on January 11, 2022, for that same amount. Your appearance for National College Student Loan, please.
Good morning, Your Honor. Timothy Tremberth on behalf of the plaintiff, P79117.
All right, thank you, counsel. Thank you for your patience this morning. Do I have Barakat, Mohammed Barakat on this room? Say something if you're here.
Yes, Your Honor, I'm right here.
All right, and good morning to you. Pronounce that last name for me, sir.
Bearcat.
Bearcat, thank you, sir. All right, so I saw your objections to the writ of garnishment. You indicated that you filed for bankruptcy in 2023. Did you get a discharge from bankruptcy discharging this debt, sir?
Yes, Your Honor, I got a bankruptcy discharge, and I got the paperwork with me.
This debt is listed on that discharge?
Yes, Your Honor.
All right, counsel?
Your Honor, did the court receive our written response?
I do not have your written response, has not populated to the court's file.
Okay, I will just go over, I have it before me, so I'll just briefly summarize. We did receive correspondence from the defendant that regarding a notice of bankruptcy filing and order of discharge. However, plaintiff contends that the instant debt is a student loan not dischargeable under bankruptcy pursuant to 11 USC section 523. We also provided a response to the defendant on that. Further, we argued that to be considered for discharge, a debtor must prove undue hardship to the bankruptcy court. We checked the docket and we did not see that discharge. Therefore, plaintiff maintains the student loan was not discharged.
All right, well, that would be an issue that you would take up with the bankruptcy court, wherein he has an order of discharge. That would be something you'd argue in bankruptcy court, correct, counsel?
Understood, Your Honor.
Yeah. And for purposes of this hearing, to the extent that there is an existing discharge, although the validity of which may be challenged otherwise, at this point, that discharge would have the impact of stopping any garnishment that might issue in this regard. I would have to, under these circumstances, find that the objection is valid. Any funds that withheld will be released to the defendant. And again, the court makes no final determination on the discharge, except that the document is what it is. To the extent that it is challenged in the future and set aside, the court will have to take that into consideration. That is my determination. I'm issuing an order consistent with the same.
Thank you very much for your honor.
Good day. Good day to you.
I'm sorry, Your Honor, am I all set?
Yes, you're all set.
Well, Your Honor, I also want to state that there is a judgment against me that was set in default that I will be filing an objection to set aside. And the bankruptcy court never sent me anything from the company that said that this debt was not discharged. This is a private student loan, not to this company.
But you're asking for something now that doesn't pertain to.
No, yeah, I understand.
Let me stop you. The fact that there is a judgment in place is a judgment in place. The debt is discharged in bankruptcy, however. That does not mean that the court sets the judgment aside or anything along those lines. It's simply that they can't collect the debt because it's discharged.
Okay. Do I have to object to the judgment to set it aside?
I don't think that you could file that, but the fact that the debt was discharged in bankruptcy does not mean that the judgment will be set aside.
Okay, thank you.
All right. Good day to you.
Thanks again, Your Honor.
All right, you all are all set. Ms. McClutchan, I see that you're here, ma'am. What case are you on?
Yes, Your Honor. You had ordered us back on body mechanics physical therapy versus Auto Club, case number 24152692.
Yes, and I see that there's a stipulated dismissal with prejudice or something that I've received.
Oh, I have not received a copy of that, Your Honor.
And I don't know that I have a copy of mine. Just the reason I didn't call it is because I have a notation stipulated dismissal with prejudice. Let me try to back that up.
I don't have that. It just shows that it was, out Judge, but yeah, the same thing you're looking at. It said placed in the sleeve, but I don't have anything for it.
Excuse me. Yeah, I see order enter dismissal with prejudice there. That's dated 4/14. I have no idea. I don't have the file. I'm looking at the register of action. And obviously I'm not laughing at you or anything. I'm just.
Right.
This is kind of strange, you know. And in fact, on 4/11, I have a stipulated order of dismissal with prejudice. So I just don't have the file, but I have, that's noted on the register of action. So we must have received something.
All right, we'll reach out to plaintiff's counsel, Your Honor, and see if he has a copy and he can send it to me.
Okay.
Well, the
And,
file is a good file in my world.
all right, then. And of course, if that's wrong, then just send something and we'll set up another hearing and go from there.
All right, perfect, Your Honor. Thank you so much. Have a wonderful day.